Hey guys, Joy from this space. Again, I am thrilled to be joined by Donna Patane from McDonald's Law. Hey Donna.
Hello.
So today we're going to talk briefly on patents and designs as part of our ongoing masterclass series. So patents and designs, I'm going to throw it to you, Donna.
Yeah, and we are going to talk really briefly because these are kind of complex things, but there's a few little tidbits I'd like to share so that you know when to be thinking about it and if it's something that might apply to whatever you're working on.
Cool. Awesome.
So, I've kind of grouped them together because they're same but different. So, and I suppose to start it off with, patents are really designed for something that is functioning. So usually it's got moving parts or it does something and functions. Examples are a mower or a toaster, an iPhone. There's something happening. Designs are also products and also three-dimensional, but usually it's because they look unique. They don't necessarily have a moving, functioning part. So same but different.
Cool.
So in terms of patents, the legal test essentially is that it's a right that's granted for a device, substance, method, or process that's new, inventive, or innovative, which I'll talk about, and useful. So there's a few boxes that you need to tick in order to have a patent granted for your product. There's a whole bunch of case law that exists surrounding what those tests are and how things happen. But I'm just going to talk about sort of the process more generally. So a patent is a right that is not granted automatically. The product has to go through a rigorous registration process, which is looked after by IP Australia, who manages all of the different IP types except copyright in Australia. And the process requires filing an application. The application is accompanied by what's called specifications, and your specification is kind of like your recipe on exactly in ridiculous detail how you create your product, how it's put together, and what it does and how it works. And it's also accompanied by what's called the claims. And the claims, are the points of difference that you are claiming makes your product different to anything else on the planet, really. So we had some changes to the law in 2012 that basically said, well, now everything's kind of on the internet and the planet's really a small place. So when we're looking at comparing your product to other things, we're going to check planet-wide. So it must be new compared to anything else on the planet. So the registration process, once all that's filed, then requires an examiner at IP Australia to look at what you filed and check the details and check how it works and what it does compared to the stuff that's already on the Australian register and the stuff that's further afield. Sometimes ask some questions, seek some clarification, get you to tweak some wording, and if it passes all of those tests, you get granted a certificate, and then you have to pay annual fees to keep it on foot. So when you are considering going through that process, the first thing to note, I suppose, is because of that issue of newness, you need to make sure that any application is filed before you publicly disclose your product. So before it is marketed for sale, say this is coming soon, before you have discussions with too many people that are not on the basis of confidentiality, that can be deemed to be disclosure. So you've got to make sure that the application is filed before the host bolts. Because if that happens and your application is not filed and it hits the marketplace, then it's no longer new. So any rights are completely lost. You're totally stuffed. So it's very important to get the application filed early on. And if you're dealing with something in this space, have the discussion with an attorney sooner rather than later. That same rule applies to designs as well. So very important to get any applications in before any sort of disclosure. So when you're considering a patent application, there's a couple of different options that you've got. So the first one is a provisional. A provisional patent application it used to be a shorter version, although due to recent changes, it's basically the same size as a standard application. And it's designed for you to file it, and then you've got 12 months during which to keep tinkering with your prototype or how it's going to work or what parts of it really make it unique. And within that 12 months, you can make slight tweaks to your specs and what the product might be doing or how it works or how it's put together. and then file your standard application within the 12 months, and you get your priority date, so essentially the date from which you have protection will backdate to when you file your provisional application. So it's a way of getting your foot in the door, still doing a bit of tweaking, but having the benefit of already filed. Disclosure is okay, and when you do file your standard, it backdates to when you initially filed your provisional. So a very useful process. Then in terms of the other types...
Just quickly, Donna, so you pay then in chunks then as well, is that right? So how does that look like in terms of like financial commitment?
Yeah, okay. So
through those different stages, don't need to go into specific amounts, but do you pay, like, is there a registration fee, is there a provisional fee, and then is there the standard completion fee? Yeah,
there is fees all the way along this road. So in terms of IP Australia's fees, there's a small, I think it's $100 or $200. It's really quite small to file the provisional application. Then there's another standard fee, which is a couple of $100 to file a standard application. And once you've done that, you've got to request examination and pay an examination fee, which I think is $400 or $500. So you can push a couple of those along the road. One of the other sort of financial benefits of provisional used to be that you didn't need full specifications. So you wouldn't need to pay your lawyer or attorney, fees to prepare full specifications to do a provisional application. You would just do sort of a short version, almost just the abstract. But because people were using that to file, an abstract basically that was too broad and then changing the hell out of it within that 12 months, the system wasn't working how it was designed to work. Yeah. So that changed in the 2012 as a pretty big overhaul of the legislation in that year. And now you do need basically full specs when you file your provisional, which means you basically need to outlay the full lawyer attorney fees to do the specs before that point. Previously, you'd just pay a little fee and then pay for the full specs just before filing your full application. Alas, that's no longer the possibility.
That's changed, hey? One of the things I heard early on is that when you're looking at patents particularly and design registrations, it's kind of like doing your own surgery. If you attempt to do it by yourself, you really need to know what you're doing. Otherwise, the consequences can be dire.
Correct. Then you've got something that you can't enforce when you want to enforce it. You've disclosed enough detail, so you can't file a new one now because it's no longer new. It's completely stuffed. And I have seen there's very special rules around who can actually sign off specifications. And it's basically a registered patent attorney or the applicant. And anytime I've seen one done by an applicant, the claims in particular are just completely wrong. And references in the legislation to things such as useful don't require you to set out how that product is useful to the market. It's useful in a different way. So all the terminology is very specific. And the way you describe things is very specific. And the protection you get is 100% based on the wording that is used in those specifications and claims. And if it's not good, then you've got nothing to enforce.
So in terms of like someone that's thinking about going down this realm, like I sort of say to people, it's just a consideration. If you are working on an idea where you have a patent like opportunity or patent, the potential to file for a patent, there's an upside and there's a downside. The upside is that you work towards having some defendable IP. The downside is that there's a real cost involved in actually securing that up front that you need to consider. So it depends on your propensity to risk whether this idea for you individually is going to be better than another idea. It just needs to be weighed up at this early stage of I even think at the idea screening stage.
Yeah, yep, definitely. Great point. And then when you do, because of what you have to file, you've got to file full specifications, those get published. And it's quite possible that someone might see the published specs and be able to put it together and get it to market bigger and faster than you could. And then even though you've filed your application and you've got enforceable rights, you've got to sue them and you need money to sue for infringement. So particularly in, where the product is something that might be, in the tech space where products live and die sort of overnight, it might not be worth going through this process, and it'll take you sort of 3 years to get your patent granted. So it's not quick by any means. And, you know, then trying to compete with someone else who might throw it into the market quicker, and then by the time your rights are registered, it's too late, the product's had its day. And so it's definitely something that should be part of a holistic IP strategy discussion. Your product.
And the intention is not to deter you from, if you're looking at a patent, to deter you, it's just to go in with their eyes wide open so that you're aware.
Yeah, definitely.
Cool.
So then, once if you've chosen to go through the provisional path, and that's totally optional, your then option is to flick it to a standard application, which is a product that is completely inventive, nothing else like it. Here's what makes it, you know, completely new to the market. And if you get that through the process, you'll have 20 years worth of protection. So you have exclusive rights to exploit, so to make the product, to sell the product, to license the product, to import the product, export, for 20 years, backdating to either when your provisional or your standard was filed. The alternative is, if you've got something that's kind of new but doesn't quite tick off the inventive test, is to consider an innovation patent. And it has a lower test of requiring an innovative step over existing technology. So it's not something that's, you know, bam, wow, but it's still kind of cool. You can probably consider that as an option as well. It's a lot quicker. It's quite a bit cheaper as well. It has less requirements in terms of your specs, etc. But you'll get 8 years instead of 20. And that's something that's quite popular in the tech sort of space because of that time frame, and because it might only be a little change here and a little change there. It's not ticking off the inventive test requirements. But there is currently consultation afoot proposing that we get rid of the innovation patent options, because Australia is kind of unique in that we're still offering it and a lot of other countries simply don't. So they might be going bye-byes sometime soonish. Until then, though, consider it, and if it's what you need, then take that path.
Is that a good segue to discuss like the requirements for Australia and internationally? The different.
Yeah.
So we're talking to doing this in Australia, but that just protects you in Australia, right?
Correct. Yeah. So and that's what my PCT means as well. So each country has its own legislation which affects what goes within that country. So therefore, a patent that is filed for in Australia and granted in Australia is enforceable within Australia. And in order to have that same sort of protection in other countries, it needs to have the same sort of process in those other countries. So 151 countries have become parties to the PCT, which is the Patent Cooperation Treaty. And it's designed as a process to facilitate protection in other countries by allowing you to do it through WIPO, the World Intellectual Property Organization, through one application, which essentially sort of puts you on the list of all the other countries. And once you've satisfied some, basic application details in terms of your inventors and names and that sort of stuff, you can then select which countries you would like to enter national phase. And that means then the patent goes through the same sort of process as it does here in those other countries. So if you get your patent application sort of underway in Australia, then, or you can suppose do them at the same time, or one or the other, and choose to go through the international phase. You file through WIPO, and then you would say, okay, we're going to be selling into, quite often it's, New Zealand, the US, Japan, maybe. Pick which countries you're Singapore, which countries you're really interested in, pay the fees for those countries, and it goes through a same sort of examination process in those countries. So they do say that the PCT process is the international patent sort of process, but there's more than 151 countries on the planet. And really it just gets you that foot in the door. You don't have protection until you tick and pay for national phase for all of the countries, or at least the ones you want.
So just to wind back, so when you do the Australian application, they check globally to make sure that it's, say, the standard application, that it's new to the planet.
Yeah.
So fundamentally, they're doing those checks again in those other countries to say, hey, we're going to check as well to see if it actually, we can't find anything.
Correct. They're not going to say, well, Australia already did it, it's fine. There is an international search that goes on, and you pay just over $2,000 for that to happen. So each of when you send national fade to each of those countries, they'll get a copy of that, but they will always, because they're subject to their own rules and they have their own registers, they will always do their own examination as well.
Yeah, wow. So, yeah, again, it's just part of the consideration, isn't it?
Yeah, and you can even find that because of, tweaks in legislation or tweaks in what else is on the national registers, you might find that it'll pass in one or two countries and then not pass in some others. So, yeah, it's a big process to go through if you're picking a lot of countries.
Yeah, and obviously it's not an inexpensive process either.
That's right.
That's often why capital is going to be required, looking to raise investment to help you through this process. To do this by yourself, there's an investment involved.
Definitely, yeah.
Cool. So what's the electrical board there you got?
Oh, which I totally forgot to tell you about. So this is one of my favorite Whoopsies stories because the electrical board is something that was invented and was not patented and was put out to market, and because it was not protected, anyone else could make the exact same product and sell it on the shelf, and that's exactly what they did. And there was electrical boards provided by anyone, and there was no exclusivity, and therefore it was competing with price like everyone else.
And I'm sure if you're like me, I have at least 3 or 4 similar looking boards in my house.
Yeah, imagine 20 years of exclusive sales of those.
Wow.
Everyone would be kitted out already. By the time everyone else gets to market, I've already got 5. I don't need any more. Thank you.
Yeah, that's it. You'd be crushing it. Awesome. That's great. What else? Any other questions that I had? I think that's really cool. Some people talk about going for an innovation patent, but that's the PCT. That's so to go direct, you can't go direct to PCT. You still need to, or if you do go to PCT from Australia, then you still need to go back to the Australian level.
Correct. So yeah, so you can, if you decide we're going global straight up, you can file a PCT application, and it will put you foot in the door for all the countries, and then you come back and say, all right, Australia, examine and grant here, and get it done.
Does it give you any protection by getting your foot in the door, or is that more just getting you on their radar?
It's really for your date and your newness. So making sure that you've said, here's the date by which we're measuring newness. And if something else comes out after that, it's not going to affect your rights because you've predated it.
Gotcha. Gotcha. That's really helpful. I actually got real value out of that, just clearing it up, because it can be just confusing. And like you said, it does change, from provisional to standard to innovation to global. It's I think you've made it a lot clearer now. So provisional is still hanging in there from an Australian perspective, but the advantage of filing for a provisional patent at the early stage is almost going away. It's almost like you've got to consider the standard straight up. And if you're looking at international, there's value in actually filing to WIPO a PCT to get to timestamp your newness, but then you've got to then funnel the individual applications down to the individual countries.
Yeah, and I mean, there's some time frames on when you need to hit the button on that, and it can be, up to sort of 30 or 33 months after you file, so you can kind of stage out the costing. But yeah, it's certainly something that, you don't go into this process hoping to wing it as you go. You really got to have a plan.
Strategy, yeah, awesome. IP strategy.
Yeah.
That's awesome, Donna. Any other comments before we wrap up? Patents or anything else people should know?
I don't think so. I think that's probably enough information to be like, what?
Yeah, cool. And obviously contact details below for Donna. If you do have any other questions, you can get hold of her there. So designs.
So now in comparison, this is going to seem really easy. And it kind of is. So it's a lot easier in that design registration is really for items that don't have all that functioning part. So the application that you file for a design is a bunch of pictures. So it'll be a drawing of the 4 different angles of the product, and top and bottom, and sometimes isometric, sort of 3D. So you would use a couple of different angles to show what it looks like. and the legal tests in terms of what you can file relates to shape, configuration, ornamentation, and some kind of unique appearance. Most of the stuff that's on the design register is, it can be used for fashion, for different types of fashion, shoes, footwear, that's usually in my space. And furniture, a lot of furniture in the design register, because it's cool and funky and it's three-dimensional, but there's no moving parts. So vehicles even can be in the design registration register. So the registration process is similar in that you have to prepare an application, file it, it gets examined. It has a similar requirement in terms of newness. So there's a test to make sure there's nothing out there like it already. And if it passes all of those tests and the examiner is happy with it, you get a registration certificate. Design registration is shorter than your standard patent registration. So it's 5 years and then you pay a renewal fee to get another 5 years. But quite often, a lot of these kinds of things will have a bit of a shorter life cycle anyway. And it is possible that your product may be across more than one of these types of registrations. So, the iPhone has patent registrations for its functionality, and it has a design. It's got a couple actually of design registrations for how the phone looks, the size of the screen, all of that sort of thing. So it might be that you're playing in both of those fields, in which case, again, part of your IP strategy, work out at the outset which one you need, which one we're going to go for. If you're in patents and designs, get the application filed before you publicly disclose the product. And then all that going to plan, you've got enforceable IP rights, which means a right to sue if someone is exploiting or using or selling or importing that product without your consent.
Cool. Awesome. Coca-Cola bottle is an example of that as well.
Yep. Unique shape. Mm-hmm.
Yep. Great. So pretty straightforward.
Oh, I should mention, so in terms of, because this comes up a little bit, I've had a lot of clients say, the US has a design patent for, my widget or whatever it is.
Yep.
The US system is a little bit different to ours in that we have two completely different systems, two totally different registers, two sets of tests, and they're both, operating in their own silos. Whereas in the US, there is essentially one sort of system, and you pick whether it's essentially a functioning patent, which is our patent, or a looks design patent, which is our designs. So a design patent in the US is a design here.
Gotcha. And is it something that needs to be filed? Is there a way to do it effectively internationally as well? There is a convention allowing that sort of registration system as well, and it's similar in terms of you file through your local office, it goes through WIPO, and they manage the process from there. But it's still, in order to get enforceable protection, it still needs to be examined and registered in the other countries. Yeah, wow, cool. Fantastic. Thank you for your insights and sharing. I think that is no doubt going to help make it easier for people to decide what's the best course for them and their products. Anything else before we sign off from this masterclass? So we've been through patents, we've been through registered designs. Anything from you, Donna?
I don't think so. Just, be sure to have the discussion early enough.
Yeah, cool. And obviously the NDAs that we discussed in a separate masterclass would work alongside this as a tool to help keep your IP secure whilst you're having critical conversations.
Yeah, definitely.
All right, thanks, Donna.
No worries.